After the governorship election, there has never been any IPAC election in Anambra State. There has never been any IPAC meeting in Anambra State. And there was no resolution whatsoever as it concerns the Central Senatorial Zone election that is outstanding and which all of us are eager to see is conducted. We now resolved in our meeting to disclaim whatever Comrade Batigwe has written and circulated as a press release by IPAC Anambra State.
We, the concerned state chairmen of all registered political parties in Anambra State, wish to make the following clarifications. 1. Inter-Party Advisory Council, IPAC Anambra State, is the umbrella body of all registered political parties in Anambra State with a code of conduct, and therefore not a willing tool in the hands of a few aggrieved individuals for the prosecution of personal vendetta. 2. There was no time the Inter-Party Advisory Council, Anambra State, met, resolved, and accepted the Federal High Court judgment of 13 December 2017.
Welcome back, everyone. Let's get back to it. There is one seat in the Senate. Out of all the senators there is one state that is not represented, or perhaps one senatorial district in Nigeria that is not represented, and that is the Central Senatorial District of Anambra State. That seat has been confronted with series of court cases, left, right, and center. INEC has fixed next Saturday, January the 13th, for the election. Will it go ahead with all of the series of court cases and judgment hanging over it? Senior Advocate of Nigeria, Mike Ozekhome, has been talking to us on this one. INEC is waiting on this one also, and we get some more perspectives as the day goes by. Well, Chief Ozekhome, you were breaking it down, but the question will be, there are, out of the different judgments on this matter, I do know that there is a Court of Appeal judgment asking INEC to conduct this election. As a senior lawyer, of course, which one should INEC obey? A High Court judgment or an Appeal Court judgment?
Yes, let me give an unsolicited legal advice opinion to INEC for which they are not paying. And that is that they will be treading the path of contempt of court proceedings if they go ahead to hold the election, the rerun elections on Saturday. It is just unfortunate that when two elephants are fighting, it is the grass that suffers. It is Anambra Central that has been denied of a senatorial representation since 2015. For the avoidance of doubt, the case of Dr. Obiora Okonkwo, which the Federal High Court Abuja decided on the 17th of December, was a pre-election matter under Section 87 of the Electoral Act, which assumed a life of its own. And the election petitions are sui generis. They are a different category of matters from ordinary civil proceedings. Ekunife had won the PDP elections. It must be noted. But Dr. Obiora Okonkwo's challenge under Section 87 against his own exclusion from participating had been dragging on since 2014. That was what finally came up before the judge, Justice So, on the 17th. All the appellate court matters that you are talking about, or that INEC is trying to rely on, were matters that did not involve pre-election issues. They did not even involve Dr. Okonkwo as a party. He was not even a party to them. In any case, their external solicitors' legal advice made this clear to them. In any case, some of those matters, one between PDP and INEC, is right now at the Supreme Court. Another one will be between APC and INEC, is right now at the Court of Appeal. These are in the public domain. The question is, why would INEC, as an unbiased umpire, who is supposed to hold the scales of electoral justice evenly between all parties. What is there to worry about? This is when that oxymoron becomes important. Make haste slowly. Is there any reason why they must
big question is, if I may quickly come in here, I understand, or I know that on Wednesday, Dr. Obiora Okonkwo has joined several other parties in this case, and the case will be heard on Wednesday. And also, I know that there is a contempt of court judgment that has been filed against the INEC chairman and INEC on this one. The big question is, the appellate court judgment that is on the ground, has that been appealed at the Supreme Court level? Or what exactly would you say that INEC should do with that judgment, which in law supersede any other judgment except for the Supreme Court judgment?
No. There are two different kettles of fish. The appellate court judgments involve PDP, APC, and INEC. They were not pre-election matter. Dr. Obiora Okonkwo's matter was a pre-election matter, which started since 2014 and was decided on the 17th of December. And that is the exact matter that is relevant to the issue of whether there ought to be a rerun election in Anambra State or not. So, in fact, like you have said, INEC itself has even filed a motion against that judgment of 17, telling the court, the Federal High Court, to vary the judgment. Do you know why? Because it cannot appeal against the judgment, knowing that it was a consent judgment to which they voluntarily, submitted themselves.
And I'll quickly just ask you this question.
We want you to vary it, and we want you to decide
Mr.
Ozekhome, quickly.
The big question will be, should the election go on Saturday, what will Mr. Okonkwo be left with? In any case, can he assume to be a senator even when he's not being offered or given the certificate of return as ordered by the High Court?
Do you know what? Section 75, subsection 2 of the Electoral Act has answered that question. Like Nostradamus, the man who saw tomorrow, the makers of the Electoral Act were probably aware in futuro, in the future, that a situation may arise where INEC may unwittingly or willingly refuse or ignore to issue a certificate of return to a person declared the winner by court of law. And you know what Section 75, subsection 2 says? It says Dr. Okonkwo can get a certified true copy of the judgment in his favor and present it to the Senate President.
All right.
And that certified true copy shall ipso facto, those are the words of the Electoral, shall ipso facto be deemed to be relevant and proper.
Senior Advocate, I want us to anchor at this point, and briefly, I want us to quickly do so. Mr. Obiora Okonkwo just participated in the primaries. In fact, I understand from my own investigation that he was far away in Russia. He was not even in the country on the day of the primaries, and he was not part of the election. He does want to benefit from what he did not labor for. Is that not how it comes across? Quickly and briefly, if you just anchor on this note.
Quickly, very quickly. The case of Amechi and Omehia, we all know, has said a political party wins elections and that an individual could assume the shoes of that political party to be declared winner. But Section 141 of the Electoral Act later came and said, you must have participated in all the processes leading to your victory. That itself is another matter entirely, which the people against whom Dr. Okonkwo has sought and won a victory can go to court and say, this is what we think. But they cannot willingly disobey the order of the court that he be sworn in. If you don't like an order, appeal against it. Then file a motion for stay of execution. But they cannot do that this time because they consented to the judgment. So the best they could do was to say, vary this order that you have made. If you say vary the order that you have made, How can they still go ahead with the rerun when they themselves have submitted themselves to the jurisdiction of the court? That will be violating a clear order of a court of law, and they will be running foul and into the cold embrace of contempt proceedings. Chief Mike Ozekhome, Senior Advocate of Nigeria, always a pleasure having your thoughts on these very kind of knotty issues that has to do with the law. Well, we will follow the situation up to the court on Wednesday, and of course, if it goes on Saturday, there is the election hold. We will also bring you all the details. That's our show, everyone, for tonight. Many thanks for being part of it. I'm sure Kim Aloye. Bye-bye.